zoning hearing board. My name is Dennis Tooley. Other board members are Chris Shirk, Stuart Hassel, and our solicitor is Keith Kilgore. I'm going to let Keith take over from here as far as the procedure we're going to follow this evening.
Thank you, Mr. Chairman. My name is Keith Kilgore. I'm the solicitor for the West Cornwall Township Zoning Hearing Board. We're going to do a little bit of housekeeping. I'm going to mark and admit a number of exhibits. Record. Exhibit number 1 is the petition for appeal before the Zoning Hearing Board of West Cornwall Township, case number 1-14, filed on October 16th, 2014 by Doug Lorenzo, am I pronouncing that right? Pamela Bishop, Philip Stover, and other concerned citizens of Lebanon County. The exhibit also includes a number of exhibits attached to that initial petition. The second exhibit number 2 is an amendment to exhibit number 1, filed by the same individuals to the same case number, dated October 28, 2014. Exhibit number 3 is a notice of the public hearing as it appeared in the Daily News. Exhibit number 4 is various communications with the Daily News as to the publication of the notice of hearing. Exhibit number 5 is a copy of the notice of hearing as it appeared in the Daily News on November 27 and December 4th, 2014. Exhibit number 6 is an affidavit from Song Kim, the zoning officer for West Cornwall Township, as to the posting of the property in question here tonight. Exhibit number 7 is an email that I forwarded to all council concerning the fact that the initial posting had the correct date and time, but had 2 places for the hearing, one the West Cornwall Township Municipal Building and one this particular facility. The correct posting was placed on the property. The notice was posted on the door at the West Cornwall Township Building, and Deborah Dahl, the secretary for the township, is at that building from 6:30 tonight until 7:30 to direct anybody who may mistakenly come to the hall to this building. The procedure outlined in that email was agreed to by all parties. Number 8 is an affidavit by Deborah A. Dahl, the West Cornwall Township Secretary, as to the posting of the notices on the door at the West Cornwall Township Municipal Building. Exhibit number 9 is an affidavit of mailing to various government officials and affected property owners in relationship to the property. The procedure for tonight is basically as follows. If we take testimony tonight, Mr. Yoder, who represents the petitioners, will present testimony first. Mr. Andrews, who represents Sunoco, will have the opportunity to cross-examine those witnesses. When Mr. Yoder is done with his witnesses, Mr. Andrews will have the opportunity to present any witnesses that he has. Mr. Yoder will have the opportunity to cross-examine those witnesses, and there are other things like rebuttal, rebuttal, and stuff like that, but I don't need to get into that. I'd like to remind the audience, because sometimes issues such as this can be emotional, that you should treat these proceedings and conduct yourself like you're in your church, synagogue, or mosque. We don't expect any interruptions, no catcalls, no applause, and if members of the audience do, they're going to be asked to leave. We'd also ask you all to turn off any of your electronic devices that you may have, including myself. And if anyone happens to be wearing their hat, we'd ask you to remove your hat as well. At the conclusion of any testimony that's presented tonight, members of the audience will have a chance to express their views to the board as follows. The first set of speakers will be limited to West Cornwall Township residents only. You'll have to come to, there's no microphone here, so you'll have to come to the front of the room, be sworn in, give your names, addresses, and the township in which you reside and the township. Each member of the audience will be limited to 2 minutes. Subsequent speakers are asked not to be repetitive regarding previous comments to the board. If they become repetitive, the board will move on to the next member of the audience. After all residents of West Cornwall Township have had an opportunity to speak before the board, The board will recognize non-West Cornwall Township residents who will be limited to 1 minute. And again, they will come forward, be sworn, give their names and address in the municipality in which they reside. It is recognized that many issues have been raised by the appellants and the petitioners. The board and I have had the opportunity to review all of the pleadings filed, including a decision in order by the Pennsylvania Public Utility Commission dated October 2nd, 2014, regarding the status of Sunoco in this case as a public utility. The PUC found that Sunoco is a public utility. As a public utility, the only zoning issue to be considered by the zoning hearing board tonight will be the 2 buildings that are on the premises. The buildings may also be exempted from consideration by local municipalities if the buildings are considered to be reasonably necessary for the convenience or welfare of the public, not by this board, but by the Public Utility Commission. The Public Utility Commission order of October 2nd remanded the issue to an administrative law judge to determine at a later date as to whether or not these buildings are to be considered necessary for public convenience and exempted from zoning. That issue is most likely to occur next year. In review of the pleadings, and I also have looked at the plan that was filed, the land development plan. There are only 2 buildings in issue. One is an enclosed 14-foot by 52-foot power distribution center and a 35-foot by 50-foot pump equipment enclosure. I have informed counsel for Sunoco and to the petitioners that the board will be limiting testimony to these 2 buildings. What equipment is within the buildings as it pertains to the public utility is not within the purview of the zoning hearing board to decide. I have communicated with counsel to present argument this evening as to whether or not this hearing should be continued until a decision is made by the Public Utility Commission as to the exemption of these buildings from zoning. Since whatever testimony that would be taken tonight or any subsequent hearing would be mute if the Public Utility Commission decides these buildings are exempt from zoning regulations. After we hear arguments from counsel, the board will make at least an initial decision as to whether or not this matter should be continued. If the matter is not continued and the board takes testimony, we will conclude testimony and any public comment at 10 p.m. today. If there is any additional testimony that needs to be presented or comments, we will continue this hearing into a later date, and this hearing would not be considered the last hearing regarding this particular matter. Now, Yoder and Andrews, if you want to comment to us as to whether or not we should or should not proceed tonight, we'd like to hear those comments, and I'll start with you, Mr. Yoder.
Thank you, Mr. Kilgore.
In addition, I guess, can you both identify yourself for your record and who you represent?
Sure, my name is Dwight Yoder. I'm here on behalf of the petitioners, appellants, in the matter before the board.
And have you given your card with your name?
I have.
Good evening, Jonathan Andrews, McNees, Wallace, and Nurick, 100 Pine Street, Harrisburg, Pennsylvania, 17108, here on behalf of Sunoco Pipeline LP.
Thank you, gentlemen.
Thank you, Mr. Kilgore, for that introduction. Let me just first indicate that I think it's important to provide an overview for the board in order to answer your question in terms of why we're appealing and what we're appealing. So with the permission of the board, I'd like to do a brief opening explaining what we would present and, in fact, explaining why I think this board can make a decision tonight and we do not need to continue this. The issue that we've appealed, let's be clear, is a procedural issue. We're not here to ask the zoning hearing board tonight whether this pipeline or this pump station should go in or not, or whether pipes should be removed. That's not why we're here. Okay? We have appealed the zoning officer's decision to issue permits. The reason we're here tonight is for a limited issue. Our position is Sunoco has to follow the rules just like everybody else. And because the rules weren't followed, the permits that were issued are invalid. I just want to be clear why we're here tonight, so we are focused on the issues. Let me explain what happened and why our position is the permits that were issued for these buildings are invalid. Essentially, when you look at the West Cornwall Township ordinance, this property is located in the manufacturing district. And within the manufacturing district, it allows certain types of uses, including a manufacturing, processing use. That use, however, is only allowed by what's called a conditional use. It's not allowed by right. You have to go through another step before you're allowed to use it that way. Okay? In addition, the township's zoning ordinance includes an exemption for public utilities. Mr. Kilgore already mentioned it. And I have actually sections here highlighted that I'd like to walk through to explain why in this case, regardless of whether the PUC ultimately rules whether this building is for the public convenience or not, the permits that were issued are invalid as a matter of law. So this is simply excerpt from the zoning ordinance that I think will help frame the issue as it relates to this initial determination. When you look at what I've handed to you, I copied section 27-1722 of the West Cornwall Township zoning ordinance. And it says there is an exemption, public utility exemption. We talked about that a little bit. I've highlighted the key portion of that section. And essentially it says this. And this is the rules that we have to follow. Before the zoning officer can issue a zoning permit and a building permit and a use and occupancy permit, the landowner or the applicant has to show that if there are other permits that they need to get, that they have those in hand. This isn't a unique process. This is well established in how it works. I go to build a house, okay? I don't get to pull my permits unless I have the other permits in place. Okay, I don't get to use it and occupy it until all the permits are in place. Okay, it's a simple concept, easy to understand. Okay, so in this case, even if this was considered an exemption, the township zoning ordinance makes it crystal clear, and I'll read it for the sake of the audience. Said permit application shall include any and all approvals required by other agencies for the use specified. Okay? So, if in fact it is exempted, they still have to have the other approvals. Now, let's say it's not exempted, and as I understand it, the zoning officer viewed this as a manufacturing use. So if you look at the next page, this is section 27-1502, and it indicates there that manufacturing, fabricating, processing, compounding, or treatment uses are permitted in the manufacturing district, subject to a conditional use approval. Yes, sir.
Sorry to interrupt. So you said that if the one approval, if the one permit is granted, they still have to have the other approvals. What other approvals are we talking about?
There are two approvals from the state, as I understand it. One's an operating permit that they need, and one's an air quality permit. Okay? And those permits need to be in hand before they can proceed.
Proceed to what? Apply for a permit?
Before the zoning officer can issue a zoning permit, a building permit, and a use and occupancy permit. Exactly.
So how would we know that?
How would you know what?
What you're talking about?
Well, this is my opening. This is exactly what we would present, that there are permits that have not been obtained yet, and they weren't obtained at the time that the zoning permits were issued. So those zoning permits are invalid. If you proceed to look through this, if you look at the performance standards under section 1503, it says, no use and/or activity shall be established, expanded, reconstructed, or relocated in the manufacturing district unless and until certification is provided to the zoning officer satisfactorily demonstrating compliance to the performance standards of this section. Certification shall consist of approvals through state or federal permitting authorities, reports or analysis by private consultants, engineers, etc., or other acceptable sources. There's no dispute that that was not provided. And in addition, in order to be entitled to a conditional use, there's no question it had to go through a hearing before the Board of Supervisors. And that's not in dispute. And the zoning officer simply issued a permit without requiring Sunoco, in this case, to obtain conditional use approval. So regardless of whether this is a public utility building that is exempted, or in this case, remember, this case, the permits were issued as a manufacturing process. Because the exemption's not in place. As Mr. Kilgore indicated, that is on remand before an administrative law judge. But we don't know the answer to that question. So the only way they could get issued this permit was as if this was a manufacturing operation. And we know they didn't follow the procedure. That's not disputed. In fact, I think everybody would stipulate tonight that they did not get a conditional use approval, and therefore that zoning permit was issued incorrectly.
Judge, I would not stipulate that the permits were issued incorrectly.
That's fine. My point was, I suspect would stipulate there was not a conditional use hearing and approval. Unless we all missed that.
I don't know that. No.
But we can certainly establish that through testimony. The remaining portions of what I handed to you, I outlined exactly in the zoning ordinance the requirements that the zoning officer has that says there's no latitude. If you look at section 27-2201, this is what it says. The zoning officer shall administer this chapter in accordance with its literal terms, and he shall not have the power to permit any construction, use, or change of use which does not conform to this chapter. So this isn't a discretionary decision. The zoning officer is charged with literal enforcement of the zoning ordinance. Section 2202 sub 3 says, no building and zoning permit shall be issued by the zoning officer except in conformity with the provisions of this chapter. If you turn the page, it makes it clear at 27-2203C that all permits related to this have to be submitted before the zoning and building permits are issued. And then it has a process if the application is incomplete, which essentially says you can't issue the permit. It has to be complete. Now what happens if, in fact, a permit is issued improperly? If you look at 27-2206, the next page, sub A, it says a building and zoning permit shall be revoked in writing by the zoning officer for any of the following reasons. And then I underline when the original decision of the zoning officer did not conform to the requirements of this chapter. And finally, if you look at 27-2404, this is where the zoning hearing board comes into play. In this case, my clients have appealed the decision of the zoning officer to issue these permits because the process wasn't followed. And the zoning ordinance gives the zoning hearing board not just the right, but the mandate, in this case, to reverse or revoke or modify those permits and be sure that the process is followed before the permits are allowed to be used. So what we're here tonight about is really the process. It's about how this occurred. And Mr. Kilgore is correct that there is an ongoing Public Utility Commission's hearing that is exploring whether these buildings fall under an exemption that would exclude oversight by local municipalities. That is correct. However, the zoning permit and the building permit were issued under the ordinance as a manufacturing use. So that issue is ripe. And even at the end of the day, if it's a public utility, the zoning ordinance makes it clear that you still have to have all your state permits in hand. So at a minimum, we know there was no conditional use review. We'll put that into testimony. I don't think there's any question about that. We know the ordinance requires a conditional use review, and therefore the permits that were issued were premature. And one last thing, the conditional use process serves a very important role. There's really two things that I would just highlight. First of all, it requires Sunoco to come in and present to the Board of Supervisors what they want to do in a public forum, allow for questions, and also they have to meet the standards of the ordinance. Second, it allows the supervisor to impose reasonable conditions on any approval. By short-circuiting that process, not only is it invalid, but it short-circuits a very important part of how these decisions are made. It totally cuts it out. So in this case, Sunoco requested permits as if this was a manufacturing use. That's the route they picked. They certainly could have waited. They could have waited till the PUC made a determination, and at that point they could have said, we don't need to go to the township. They chose not to do that. And the only reason that I can think of why you do that is because you want to start using this facility right now. And if they want to start using it right now, then they have to use it based on the permit that the zoning officer issued as a manufacturing use. And again, our position is that permit is invalid. And this board should revoke that permit and force them to go either through the correct process or, as Mr. Kilgore suggested, wait until the administrative law judge makes a ruling on whether it's exempted from local zoning ordinance. Thank you.
Thank
Thank you, Mr. Kilgore. Good evening, gentlemen. Again, for the record, my name is Jonathan Andrews with McNees, Wallace, and Nurick, here on behalf of Sunoco.
John, can you speak up? I don't think somebody...
Sure, I apologize. I'll speak up. I appreciate Mr. Yoder's summary of the case in chief that he intends to put on tonight, but I want to get back to the point, which was the question posed to both of us, and that's whether this hearing should be continued because of the 619 petition pending before the PPUC. And the simple answer to that is yes. Let's remember, as Mr. Kilgore set it up, the only things subject to tonight's hearing are the buildings. It's not any of the other equipment or facilities at the pump station. It's just the buildings. And in reality, it's simply the roofs and walls. It's not even the equipment inside. So all we're talking about is buildings. And the question is, does the municipality have the right to zone buildings? Or is that under the PUC's jurisdiction? There's very clear case law that guides us tonight and makes it very certain that this hearing should be continued because of the petition pending before the PUC. Back in 1954, there's a Supreme Court case, Duquesne Light. There, a municipality tried to stop an electric company from putting transmission lines across the municipality. It was a township. The Public Utility Corporation, in that instance, sought an injunction, which was granted by the court. The court said, public utility facilities are exempt from zoning. Municipality, you can't stop them. Now, those were non-building facilities, I admit that, but the court, the Supreme Court in that instance, gives us very good language, and I'll pass out a copy of that case to both sides here. I'll turn your attention to language, and this is in the Duquesne Light case, on what's marked as page 5 in the bottom right corner. Section 3110, I've highlighted this for you. That's of the First Class Township Code, merely grants an express power to zone with respect to buildings of a public utility company, subject to a determination by the commission that the present, the commission being the Public Utility Commission, that the present or proposed location of such buildings is not reasonably necessary for the convenience or welfare of the public. So it's saying municipality can zone buildings if the PUC has determined that the buildings are not reasonably necessary. Now you might say subject to is a little bit open to interpretation. Well, we got that interpretation 30 years later from the Commonwealth Court. This is a different case. This is South Coventry Township. In South Coventry Township, the court looked at the Duquesne Light decision to see what was meant by the Supreme Court. And this is on page 4. There's a highlighted paragraph. First, based on our conclusion above, Duquesne Light establishes as an enduring principle that there is no power possessed by municipalities to zone with respect to utility structures. We all know that, that's well established. Other than buildings. Of course, only after the PUC has reached a determination with respect to the public convenience need for the building. What the court is saying there is, if a public utility has petitioned the PUC seeking a determination about its buildings, the municipality can't zone, make a decision, the zoning hearing board can't rule on appeal until after the PUC has acted. And this makes sense. It's consistent with the whole policy that's involved here. What the policy underlying all these cases is that public utilities crisscross municipalities. They can't be subjected to the twisted knots of this municipality's rules, which is different than this municipality, which is different than this one. They should be subject to a statewide jurisdiction, or an agency of statewide jurisdiction, in this case, the Public Utility Commission. I agree, if the Public Utility Commission determines that our buildings aren't reasonably necessary, we're back here and we're talking about these permits. But it's premature to sit here and discuss them tonight in light of the pending action before the PUC. That's where this belongs for the time being.
Thank you.
Mr. Kilgore, may I just briefly respond? Sure. And I apologize. Sometimes when you come to these meetings, you feel well prepared, and then you skip over the very first thing on your list, which is, I should have introduced who's with me this evening, and I apologize. Jolie Van Horn is another attorney in our office, and she's worked hard at looking at these issues. Mr. Lorenzo, Ms. Bishop, Mr. Stuber, they're all my clients, and again, I apologize for overlooking that. If I could just have one quick response to what Mr. Andrews said, which is, the fact of the matter is, they went and they sought the permits from the zoning officer. Why seek the permits if you don't need them, if the local township has no jurisdiction over it? If in fact they want to wait to use this facility, I agree. We're happy to sit and wait. And if they want to say on the record that they will wait till the PUC makes a determination, we are completely willing to agree to continue this until a determination is made. But we did not hear that tonight. They want to, under the authority of the zoning permits, begin to use this facility. That's a different issue.
Let me ask you devil's advocate question. Don't they have to be able to use the facility from one end to the other? Not just something in West Cornwall Township?
I'm not sure I follow your question.
Well, if you're gonna pump propane under pressure to, I think it's Marcus Hook, you have to do it from the source all the way through the Commonwealth to Marcus Hook. You can't just look at West Cornwall Township in, by itself.
I don't disagree with that from a practical standpoint, but remember,
But they're gonna need permission to go from one end to the other before they go through West Cornwall Township. Am I right?
but they're gonna need permission from West Cornwall Township as well.
Well,
And that's what we're here for tonight. Okay, I agree, you have no jurisdiction over anything outside of West Cornwall, no question about it, but there was a reason they went to the zoning officer. There was a reason they pulled the permit. And the reason is, they need to have that approval because at this point, there's no determination that these buildings are exempt. You can't have it both ways. You can't say, oh, you know what, just wait, don't do anything, but then start using it. If you want to start using it before that determination is made, then you got to play by the rules that are in place, which is the local municipality. If you want to wait, fine, wait, and if the PUC says you're exempted, then we're not here anymore. Thank you.
Let's keep in mind what is being discussed when Mr. Yoder says use the facility. He's talking about equipment. He's talking about non-building facilities. Those are exempt. Those aren't the subject of tonight's hearing. Tonight's hearing is about the buildings being the roofs and the walls. You don't use a roof or a wall. You use the equipment inside, but that's not subject to tonight's hearing.
Well, and if I just may respond, I'm not sure why the conclusion is that the equipment's not subject. If you look at the PUC decision, that was specifically excluded. The PUC decision that you referenced in your email did not take a position on the equipment. And I would say they requested a zoning permit, which is a request for approval for a use.
I would disagree with you to the extent that they said that the only issue that can be before any municipality is zoning relative to buildings. It didn't say anything about the equipment inside the building, or it didn't say anything about the equipment outside of the building. It didn't say that, you know, you can, I think the decision was you can pump from east to west and west to east, it doesn't matter. You can use these pipes, you can put other pipes in, if I'm characterizing the reading of that opinion.
I think that if you look at the opinion, it specifically says we are not making a decision on the equipment.
The opinion says we're not making a decision on the necessity of the buildings, because that's yet to be determined. That's what the opinion says. And to answer the question as to why we sought permits, it's because up and down the line, we have tried to work with municipalities every opportunity we get. We have tried not to exercise our rights to exemptions under Pennsylvania law for fear that it would appear as though we were being the big bad public utility corporation. We've tried to work where we can within the ordinances, because that's the better way of doing things. But that's not always an opportunity. And in this situation, as you can see, we have to fall back and exercise our rights as a public utility corporation.
Should we take a break here?
We're going to take a short recess. The chairman would like to discuss some legal issues with himself.
Question 2 for our solicitor.
Well, wait.
You want to retire at their
Could we do a room over here?
Go sit in the fire truck.
Yeah, what?
Go sit in the fire truck.
I almost want Arizona to get home field advantage in the playoffs, and I said we get past the first round. Oh, that's true. That's a better second. I don't think so.
Okay, please, in order, sorry for the interruption. I found it necessary to ask our solicitor a couple of questions because my last law class was in 1999. So I appreciate the documents though, and I read them, the highlighted areas, and we had some questions. But thank you very much for your patience with our questions, Mr. Solicitor.
Well, in light of the comments of counsel and the cases that have been presented and the memorandums regarding the zoning ordinances, is any board member prepared to make a motion regarding whether or not we go forward with tonight's hearing or we don't go forward with tonight's hearing?
I would like to move that the hearing be continued as rescheduled, and rescheduled after the PUC makes a determination as to whether or not the buildings are exempt from zoning, and this hearing not be considered the last hearing.
Is there a second to that motion? A second. Is there any discussion on that motion?
May I just make a comment before you vote?
Sure.
Just for the record, the NFPC requires another hearing in 60 days, and we are not going to waive that right. So, for the record, I'm not sure you can indefinitely continue this. The PUC proceedings might go on for a year or more.
I'll set up another hearing in those 60 days and maybe doing that same issue now.
And for the record, Mr. Kilgore, Mr. Chairman, the time periods under the MPC can ultimately lead to a deemed approval. They're intended to protect developers from municipalities dragging their feet, and they clearly apply only to an applicant. An applicant is defined under the MPC as a party seeking an application for development. It does not apply to an appellant. So there's no fear here of the zoning hearing board ending up with a deemed approval of the appeal.
Well, let me just say this. We don't want to make any procedural errors. You might be correct, and Mr. Yoder might be correct. And if he's not agreeing to waive it, and I think that there's necessity that we schedule a hearing, we'll schedule a hearing.
That's
Back
fine.
in that, and we'll argue the same thing again. All right? Okay. Thank you, John.
So
I
we
think
have
I
a
asked.
motion and a second.
There was a second, all right. I'll take a roll call on the vote since there's no discussion. Mr. Shirk, your vote? You vote in favor or against the motion? In favor. All right. Mr. Hauser? In favor. And
I
Dr.
made the
Truly?
motion, I'm in favor.
Okay. All right. Motion passes unanimously. Nothing else to come before the board tonight, or is there a motion to adjourn?
Motion to adjourn.
Is there a second to that motion? Any discussion on the motion? Hearing none? I'll take a roll call vote. Mr. Shirk, in favor of the motion? Mr. Hauser? And Dr. Truly?
Yes.
Okay, then we stand adjourned.
Thank you.
gentlemen.
Thank you. Thank you.
Thank you, gentlemen.
Put the easels up and I'm like,
Thank you.
I don't know.
Some of them are startup, some of them are advertising. Some of them
I feel bad for
Sorry, Joe.
you would sit on that. All right, you do it. I'm sorry.